absolute pleasure to be here with you today, and I'm really looking forward to this webinar and speaking with your landlords. So thanks for having me, Deb.
So, Jodine, I know that we talked about not wanting to give this info away. Between you and I, we've got a combined nearly 50 years experience in property management.
Yes.
We have agreed that we won't disclose who has which portion of that 50 years.
We started when we were 2, everyone, so that's why we look so young.
So thank you very much for joining us this evening. I know that there's a lot of people who have got a lot of questions. First of all, though, a little bit of Zoom keeping. Please feel free to ask questions. Hopefully we will get to those throughout this presentation. If we don't, then we will endeavour to get back to you, or your property manager will reach out to you and get in touch with you in the next coming days after this presentation. So please feel free to ask anything that you feel that you need to. And obviously just around COVID, as I mentioned, we're so glad to be back in level 2, but having said that, I think we're getting pretty practiced now at going into these lockdowns. I don't know about your team, Jodine, but when we heard the announcement on Sunday afternoon, there were a couple of husbands that were left stranded in a restaurant in the middle of a Valentine's Day dinner. How about you guys?
Well, I was more concerned about our Harcourt's corporate team because we all got the news and rushed in to get our computers and everything, but we were all in our active wear or shorts and things, and none of us were on hot dates. So I raised that as a matter of concern that we need to look into. But look, we are well versed at this. I went through our library, our Harcourt's library, we all have all our documents, and we didn't have to update anything, we didn't have to do anything. And I know that we just ran with it. You've got a motto, I think, with your team now, Deb.
We've developed a few over the last 12 months, but I think what really resonates with the team is we got this. We are 100% across it now, so no matter what happens, we are well equipped. We're working from home, and if we need to, we can drop everything and be ready to hit the ground running. So we're getting pretty practiced at it now. Hopefully that's the last one, but
yes, that would be,
we're always ready.
That'd be nice if it was the last one, but if it's not, we've certainly got this, which is great. So I know that you guys have adopted all the right technology, doing everything right, and that you can continue that seamless service to your landlords.
So what we wanted to talk about this evening, and this is something that you and I have talked a lot about over the years, the Residential Tenancies Act amendment, which came out in part last year and in 2 parts this year. So tell me what your thoughts are on the RTA changes.
I'm right behind them, and the more that I have investigated, learned, attended webinars, live training, all of that, the more that I support these changes. This legislation the Residential Tenancies Act is 30 years old. And the face of tenants and landlords has changed in 30 years, and the legislation really hasn't kept up. What I really like about this is the removal of those grey areas. So areas that we may not have been sure of in the past, I think we've got those reasons, they're clearer now. It's a better piece of legislation, and I think it reflects the New Zealand fabric better for us. I think there's been some speculation in the media, and there's been some alarmists, which I wouldn't name any particular media brand, but I think today, hopefully by the end of this, people will be feeling, if they're uncomfortable with some of the changes, they'll be feeling a little bit more comfortable as we address all of these and why we think they could be good for us and our landlords.
So just around that point with the media, one of the things that I've noticed, and it seems particularly over the last couple of months, every day property management has featured in the news, and it's been painted in a pretty negative light. So a lot of the feedback that's been provided has been by private investors, private landlords, people who are feeling like they're having control completely taken away from them. Now, if property managers had their input into how they view these changes, do you think it's fair to say that they're far more receptive to getting their heads around all this new legislation than maybe private landlords have been?
I absolutely think so. We are supported by the Real Estate Institute of New Zealand that all of our offices belong to. I'm on the Ryan sector group. We had a meeting yesterday, so we meet regularly. I've got a meeting, well, it was supposed to be in office on Monday with MBIE, Ministry of Business, Innovation and Employment. It's not now, it's going to be online, but that's fine. We had a member from MBIE come into our meeting in the sector group yesterday. So all of those things that I'm doing, as well as what our other offices are doing, going into the technology we use, they're doing training, everything that we're getting from different sources, and it's all correct. Whereas some of the information that our private landlords are getting is from the media, and that's often hyped up. It has been, some of it very inaccurate. And so I probably would be concerned if I was a private landlord, even through COVID, the information we got through COVID, we're able to understand it and push that out to the network quickly and in plain English. It was easier for us to flex and adapt. And it's the same thing with the RTA changes, because we are right at the forefront. We started training on this a long time ago. This has not been unexpected. So it's something that we just live and breathe. Much easier for us than for a private landlord, that's for certain.
Well, Jodine, I know that you yourself do hundreds of hours a year training with all of the Harcourts offices all over the country. My team have attended every training day that's been put out by Harcourts, by Tenancy Services. We've been to MBA, IE conferences. Everything that we can get our hands on, we do, and we are at the point now where we're comfortable, but that's taken quite a while to get to. So for private landlords, I just can't see how they could possibly have access to the amount of information and then digest it in a way that's going to give them some comfort. So I do fully appreciate that there are people out there who are feeling nervous. What we aim to achieve this evening is to, as you said, give people a little bit of comfort that with the right support and the backing, that navigating these changes is not going to be a minefield.
No, absolutely not, and hopefully you actually see it from a positive light as well. And we can talk about the accurate information that you do need to know, and put some fears. I mean, the thing is with Harcourts too, we're an international brand. We were Kiwi first and went international, which I always like. I've been associated with Harcourts for a very, very long time, and it's a great brand. We're very, very supportive of training, development, and I know, Deb, with your history as well, with the training and development that you've done, that you support with that. Yeah, like you said earlier, we've got this.
Okay, so getting into the good stuff. So
yes.
If we talk about what I think private landlords are concerned about, it's this whole new security of tenure. So I know that there's a lot of questions around what this means for landlords. Talk me through how you see the first one, which is the owner wishing to move back into the property or having their family or a work employee move back in.
So with that, they absolutely can still do that. Just the notice period has changed. Where a lot of the landlords are really concerned about is the removal of the no cause termination. And that has been, I won't be able to move on my tenants. Well, you absolutely would be able to. You just need to have a reason. And although they removed the reason that we say, but we're not telling you why, they've given us back the reasons why we said we use the 90-day no cause termination. And it's really, really important that we understand that in a 12-month period, only 3% of tenancies were ended, periodic tenancies too, mind you, we ended using a 90-day no cause termination. So all that's really changed now is they said, okay, well, you can't end a tenancy without a reason, but these are the reasons you said you use it. So here they are now in legislation, which is actually better for us because it's clearer, less grey areas. They've also given us we were assaulted or you were assaulted by your tenant, we can give 14 days notice and so on. But that's not good. We're not going to worry about that. We're not going to delve into that because that's not going to happen. So they have certainly covered this. And so the reasons why we can give notice for periodic tenancies and for fixed terms moving forward are all covered now in the Act, which will be shown on the next slide, or one of the next slides as well, we go forward.
So on this ending of periodic tenancies, I know one of the things that landlords are concerned about is being stuck with a bad tenant. However, a lot of that comes back to making sure that you're selecting the best tenant when you actually put them into the property to start with. So property management companies have access to tenant checking, background screening, which we run every applicant through. Absolutely. And that accesses 27 different databases. That's checking things like the New Zealand Parole Board, the Sensible Sentencing Trust, 2 different credit bureaus for credit referencing, a number of different things that we can use to make sure that we're choosing the absolute best tenant. So although this seems like a big concern, if you're choosing the right tenant at the beginning, this doesn't become as much of an issue, right?
That's right. And I remember I was, okay, I'll admit this, 17 years old, and I got told it's easier to put a good tenant in than it is to get a bad tenant out. And as property managers, we know this, and we make sure that right from the very beginning we set the scene with the right tenant and also the right way of inducting, the right way of handing things over, and just building that good relationship and respect. Again, I mean, but then if something goes wrong, we've got the parameters within the RTA, Residential Tenancy Act, and the amendments to move them on. I've always thought that if somebody gives us a reason to move them on, we will be able to do that.
Right, so briefly, the 63 days notice. Now, that is not essentially a new law. That is just increasing the notice period from 42 days for an owner or a family member or an employee to move into a property to 63 days. So that is essentially just giving tenants longer to be able to find a new property, be screened, go through the notice period and be able to move in somewhere else. And that just gives them a little bit more comfort around the end of their tenancy.
And I think this is one, I think what we need to remember is why. And I think that always helps us, and especially as Kiwis, because we are empathetic. Why would we extend it from 42 to 63? And I think, I mean, I couldn't imagine trying to move my family, although my daughter's grown up and moved out, but certainly when I had to be in the right schools, particular school zone, and all of that, to be able to do that within 42 days, you know, that's just, it wasn't long enough. So now that's been moved to 63. So if an owner or a family member, now it's interesting that it must be your principal place of residence. It can't be your holiday house. And you must move in within 90 days of the tenant moving out and live there for at least 90 days. And of course, for tenants, they now have to give 28 days notice on a periodic tenancy as well. One thing I also wanted to cover here with 63 days notice, a lot of you who will be on the call today may have your property owned by a trust, or you may have it owned by a company. Now, if your property is owned by a company, no, you cannot use the owner or family member moving in because you're not a person. If you're a trust, you might be able to do that. It's likely that you can, depending on how distant relationship is with the beneficiary that's actually going to be moving in. So depending on how your trust is structured, it's likely that you can use this the owner moving in, depending on how distant they are within the relationship to the trust. But you would want to seek legal advice. But that was the advice I had yesterday, straight from I won't say horse's mouth, but straight from a government official on having trust and having an owner move in.
And the other change that goes with these 90-day and the 63 days notice is that you do actually have to live in the property for a minimum of 90 days after that notice has been given. So I know that in the past we've had some difficult tenants. Owners have just said, look, tell us I'm going to move in, and then that's been it. The tenant's moved out and they haven't moved in. That's been cleared up now, so that you do actually have to reside in the property for a minimum of 90 days. Again, just clearing up all that grey area.
Absolutely, absolutely. Nice and clear, nice and straightforward. Absolutely.
Okay, so we're looking at the 90 days notice, and we've covered a couple of them already. One of the key things is, and we obviously have a lot of landlords who they have reached the end of their investment journey. Their investment property has done what they wanted it to do. It's given them great return, great capital gains, and so they've decided to sell. So one of the things that we have been made sure that we communicate is that during a notice that you've given the tenant to vacate the property, because you intend on selling it, you can't market it during that time. The tenants have to be left alone to enjoy the rest of their tenancy and decide what they're going to do as their next move.
That's right. And I think what was interesting, so we got pinged for a retaliatory notice in January, not you, another High Court's office, because we said we wanted to sell the property without the tenant in it, so we could stage it and do all of those good things. And it was a farm, for goodness sake, so it made sense to sell it without the tenant in it and market it. But the adjudicators came back and said, I'm sorry, no, that's retaliatory. You could have marketed and sold the property with the tenant in it because you may have sold it to an investor, even though we would not have been able to present it the way we wanted to. He did say on the order in January that on the 11th of February, you could have done this. So we were very disappointed with that outcome. But again, removing the grey area, we now can use that as a valid reason to ask the tenant to leave. So once they vacate, then we can go and set the sign up the day after, put the ad up in the websites on the day after they move out, just not during that period. I'll just take you back to that slide beforehand. The other one too is if you sell a property with a tenant in it, which you're perfectly able to keep doing, so you can market it with a tenant in it, which is usual. You just need to give them now, once you've got the unconditional contract, 90 days notice for them to move out. Plus, of course, that we recommend a few days for serving the notice, and then if you want to get the property cleaned, because often we do need to do that after tenants moved out because reasonably clean is not clean enough usually for somebody going back in. So now that's gone from 42 to 90 days, and most people would agree that you would need that extra time to relocate a family. If it's obviously with a periodic tenancy, the tenant can then come back and give 28 days notice. But that can be up to your real estate agent to make sure there's a clause in there that you may be able to bring the settlement forward. The other one is, of course, if you've got extensive alterations and so on to do, that the tenant can't possibly live there, then they'd need to move out. You can do that. And we're going to get a little bit more guidance from Tenancy Services going to come out and give us some clarification on exactly that. And also, if the premises are going to be demolished, it's a really good idea that the tenant moves out first.
Yes.
And
in most cases.
yes, yeah, very, very wise. We did have a tenant, not hardcores, but in the industry, try and contest that they could have stayed or something, and it was like, no, you couldn't. So, but of course, you're just really keeping in mind those things around the sales, and all of our salespeople, they have undergone quite a lot of training. I had a webinar with the Northern business owners today. We did a webinar last week for them, so they've been getting all the information they need to start to make sure that they've doing all the right things by you when it comes to selling any of your investment properties, which of course would much rather you keep them managed with our great tenants and great property managers.
We absolutely would, but just on that note, in the event, and we can't control people who do decide that it's a great time to sell their investment property, or they're at retirement age and they're ready to cash up their portfolio. In the event that that happens, I have personally done dozens and dozens of hours of training with our salespeople, and it's quite important now, more so than it was prior to this law change, that real estate agents, sales agents are across these changes, because most of these now carry new fines and penalties that they didn't have before. So in the event that you do decide it's time for you to sell your portfolio or your properties, I would recommend ensuring that your real estate agent is 100% across these changes to avoid any disturbance with the tenant, stop there being any friction or breakdown of that relationship towards the end of the tenancy, and make sure that you're not exposed to any fines. So in the event that you are at that point, you'd like to sell, then give us a call, have a chat with your property manager, and we can put you in touch with the people who we know are most across these changes.
Well, I think it's also just on that too, is if you involve your property manager early, it's likely that your tenant will give more access. Because if you if the tenant gets a phone call, God forbid, from a salesperson, before hearing from the property manager, it just sets the scene wrong, and you're asking these people for access into the home. So always speak to your property manager. They know how to have the conversation with your tenant and smooth it over for you as well, which will make the whole transition better. Okay, less common reasons. Oh, if it's a leasehold property, if you're having business next door, and these aren't very common. If you're going to turn it into a commercial property, within 90 days for at least 90 days. So, but if none of these reasons that we've talked about already applied, then you're off to the Tenancy Tribunal, which of course that means one of our experienced property managers will look after you for that anyway. So we're well trained and experienced, although we don't go there every day. Well trained and experienced, and what should, really is a fair process for landlords and tenants if there is a dispute and property managers.
Right, so fixed term tenancies. Now this is another area that I know that landlords are really concerned about, because they see it as losing control, a little bit like no longer being able to issue no cause eviction notices. So basically this means that at the end of a fixed term tenancy that was signed after the 11th of February, essentially that means that at the end of that fixed term, the property manager or landlord doesn't have any right any longer to decide to end that fixed term at that date. So it automatically rolls over onto a periodic agreement unless the tenant provides notice that they're not going to renew it.
But the other thing is though, the landlord can give notice as long as you're using one of the reasons, like I'm going to sell, I've sold, I'm going to move in, and so on. So the other reasons. So all the reasons why we said that tenancies ended, typically you would just do it that way. So if you're going to lose interest in the property, all of those sorts of things, you would simply give notice using one of those grounds, and then you can end the tenancy. If you wanted the tenancy though to end on a particular date, which was a fixed term expiry date, you need to give the tenant at least 90 days notice, or at least 63 days notice. Because those rules apply, but you don't need to get necessarily hung up on the fixed term expiry date. You could let it end, 30 days after, as long as you've given either 63 days or 90. I think we've got a slide going forward where we've got an example of that. And one thing that is interesting to watch out for is that if you've got current fixed term agreements are granted before the 11th of February, the old rules apply to that. So you can still end that tenancy without giving a reason. But then, of course, once you renew after the 11th of February, or you have a new tenancy after the 11th of February, the new rules will apply. And so, again, we typically have reasons why we would terminate a tenancy, and we've got those reasons in the RTA.
And we'll be discussing with all of our clients, if your fixed term is coming up for renewal and the tenants are good and they're looking after the property, we would be looking to renew those fixed terms with you to give you some security that you've got the same tenant in place for the next 6 or 12 months or whatever the term is that you prefer. So it's just an opportunity to have a conversation with the tenant and then look to refix that agreement.
And the tenants are likely to want to do that because the tenants want to stay as well. Because if you signed for 12 months and then you sold it after 2 months, they're still secure in their tenancy. So the fixed term tenancies are just, and renewals are just as relevant as they ever were. There was a couple of weeks ago on one of the major TV channels on 6 p.m. news, and I yelled at it. I know my boss yelled at it. She said she even knew, and so many of the Harcourt's property managers were yelling at the news station, telling them they were wrong because they said it's the end of fixed term tenancies. That's incorrect. They're just as relevant as ever. It just means that they automatically roll to periodic, which they did anyway. But if we want to terminate, we have to have a reason. And like I said, if we typically do anyway. All right.
So as we get into new grounds for termination, tell us about the antisocial behaviour.
Well, this is for periodic tenancy. So another thing, when we removed the no cause termination, we said, well, we typically give 90 days notice because we want to sell the property, so we've got that. We also, when the tenants, they haven't done anything too revolting, because of course if they do, we can go straight to the tribunal to terminate, but they are antisocial and they're causing a nuisance, and then we would typically give a 90-day notice and say, off you go, find something else. So this is why we said we did, and I'll talk about another reason what we said we did. We gave these 90 days. So they've given us that. They said, look, if your tenants are antisocial 3 times in a 90-day period, make sure you're keeping records, make sure you're doing the right notices, and we've got those all in our Harcourt's library for our property managers to use. So as long as they've done it more than minor, but not anything too minor, but as long as it's more than minor, and they will define this, and tenancy services are coming out with more tools and everything, then you can give them strike 1, strike 2, and strike 3, you apply to the tribunal. And of course, your property managers know all the ins and outs and how to do that within the timeframes, what needs to be provided, and so on. And we keep records of everything. Everything's documented anyway. So again, you have got reason and you have got ways to terminate. And I think what's important here to note with the tribunal, they look at the basis of probabilities. So if you've turned around and painted a picture, or your property managers painted a picture of their behaviour, then the tenancy tribunal or adjudicator will order termination based on the picture that you've created. Yes, that is very likely that you are right, Mr. Property Manager. We will grant you termination because they have been very annoying 3 times in 90 days.
This also goes back a little bit though to the work that goes into selecting the right tenants. So we know from private landlords who ring us asking us for a reference for one of our tenants, some of the information that they request is pretty vague. They don't have access to the databases that we've got. So in the selection process, hopefully it does weed out some of this, the likelihood of having tenants who do have antisocial behaviour. If I look back on my insert years here, history in property management, there's very few occasions where a tenant has had such bad behaviour that if I apply the current laws to it, that I would have to go through this process. And that's largely because, the work that goes into selecting a really good tenant for a property manager, it means that further down the line, you make your job a whole lot easier. So yes, we love to find tenants for our clients, but we also love to find good tenants for ourselves because we're the ones that have to manage them.
It does make our job easier if we do that, isn't it? So, and all of those credit checking, all of those things, and also setting the scene. I mean, and I know your property managers, and obviously I know you, and I know how they treat people. So, and I've seen the testimonials, I've seen all those things, as they are almost all accredited with Harcourt's now too. And their tenants like them, and those relationships are really, really important, because I think if you can build that relationship well from the beginning, which is what we work so hard to do, some of this actually becomes a conversation, and you actually say at the beginning what is acceptable, what isn't, and what sort of behaviour you will tolerate. So part of that is actually setting the scene and having those conversations, and having experience to have those conversations, like you say, and then you can avoid some of this.
So that takes us on to the grounds for termination. I think we've already covered this a little bit, but antisocial behaviour and people's interpretation of antisocial behaviour is going to be different, much like people's interpretation of a property being left clean. So this can be anything from harassment to abuse to things that really just get on someone's nerves so much that it disrupts their quiet enjoyment of their own property.
Yeah. And again, anything that's major, this is not what this is for, that would be different. This is something that is that niggly and behaviour bad enough to cause, and then it's 3 times in 90 days. So this is what you said you wanted, the 90-day no cause termination, because you did for antisocial tenants. Here's the legislation now. So grey area gone. So I think this is a welcome thing. If anyone's been worried about not being able to move on bad tenants, again, we've got the grounds to do it. Interesting though, with fixed term tenancies, just so you know, we've still got the 14-day notices. We've still got the ways to terminate very bad tenants. None of that's been removed. It's all still there. So they've given us additional grounds for periodic, because that's for that replacement no cause termination.
Okay, so this is a good one. Rent arrears is now a possible cause for terminating tenancy with 90 days notice. And I think that this goes really well hand in hand with the removal of the no cause evictions. And typically what we would have previously given a tenant 90 days notice for would have been some of those below average behaviours that we see.
Yes.
And I think hand in hand with people who don't take their responsibilities as a tenant responsibly, also there is a likelihood that those are the sorts of tenants who are going to get behind with their rent. So despite the fact that we can't just issue someone 90 days notice now for no reason, what we can do is terminate on the grounds of rent arrears if they get into arrears on 3 separate occasions, more than 5 days within a 90-day period.
Yep. What I like too is that of course we've got all our standard letters and documents, and what they'll do is they get a 14-day notice as soon as they get into arrears, and a text message and a conversation. All of that thing happens very early on day 6, which will be day 5. Once we know that they didn't pay, they will get this letter, a separate letter saying strike 1. And what's going to happen if you get to strike 2? Strike 2. What's going to happen if you get to strike 3? We're going to terminate your tenancy. So it's all the way along telling people what our expectation is and what happens if they don't meet it. So that grey area again, and it's good. It's what we said we would use a no cause termination for. So again, I mentioned the 14-day notice to remedy a breach, which is what we would also issue at the beginning, and we would do that with fixed term tenancies as well. But obviously if a tenant gets 21 days in arrears, we go straight to tribunal. That's do not pass go, do not collect $200, go straight to tribunal on that. And so that's all still there. This is additional because that's what we said we use that 90-day for.
And so this is just a little bit further on the existing provisions in the RTA. So we have always been able to do a number of things under the RTA in terms of breaches, which are things like give tenants a 14-day notice, and have they adhered to that notice? Have they got more than 21 days in arrears? Have they caused or threatened to cause damage? Have they assaulted someone? So these are things that are already in existence, but they've just been tightened up a little bit.
Yeah, and so the thing is that what way I look at this, apart from the no cause, taking that away, they've left everything else there, and then they've given us some additional grounds, but it should have cleared up some of that grey area from 30-year-old legislation.
Okay, so this is rent setting increases. This is something that has already been in the media quite a lot last year. During the COVID lockdowns, there was a freeze put on rent increases. Everything that had been already sent out prior to the 24th of March was wiped, and it was said that no rent increases could take place for 6 months, which took us up to the 26th of September. Now, during that time, the law also changed so that you could only implement rent increases once every 12 months. Now, of all of the changes in this RTA amendment, this is going to be one of the ones that has the least effect, by and large, because there aren't very many people out there who would be looking to put the rent up on their properties more than once annually.
It's exactly. So the Real Estate Institute came out and said, yep, fine. We were like, yep, fine. That is fine, because if you're doing your market rent when they move in, you're fixing the term for 12 months. So although we can increase during the fixed term, we typically wouldn't. We might still have a look at the rent and say, hey, has it moved? But your rent increases were quite typically annual anyway. If people were doing 6 monthly ones before, it might have been smaller, but you'd ultimately get to the same result at the end. And so yeah, this is fine. No problem.
And same with the bidding on rental properties. I've personally never experienced this. I've never had anyone treat a property viewing like an auction and try and outbid us on the rent. But again, this is something that we're not unhappy with. I've never seen it either. We've over 23,000 properties managed in New Zealand. No one that I've spoken to has seen auctions, so I don't know where they're happening. But I think this is fine. But it does mean a tenant can still offer you to pay more. They could still come to you and say, look, there's 30 people here.
would pay you $50 a week more. They can do that, but we just can't ask them to. And then we wouldn't be able to go back to the other tenants and say, hey, he's offered $50, will you match it or pay more? So that just makes it, I suppose, that they can still offer more, but we can't go and solicit it and start and do a bidding war. We typically set the price anyway, don't we?
Another big area that I know as a landlord, I've thought about what would happen if my tenants wanted to paint their walls purple and bright pink and green and all the colours of Dr. Zeus.
I love them.
But I think around this, it's good for people to keep in context that there is still the options to allow for this to be remedied at the end of the tenancy. What this new law change is doing is making it a formalised process, which must be responded to. It can't be unreasonably withheld in terms of permission. And then there are options to, as I said, remediate this at the end of the tenancy.
Yeah, and look, another one that came out, I don't know if anyone saw, I'm assuming you did, with the media, I don't want tenants painting my house. Well, they're not going to. It's unlikely that they're going to be able to say it's a minor change, because it's unlikely that they're going to be able to put that back to substantially the same condition, which is actually the terminology, substantially the same as before by painting it, especially all those colours you just said. So, but hey, look, if they're a painter by trade and they come and say they want to paint the house, maybe we should consider that. But look, if they make a request, what we're looking at really is someone make it their home, and we want them to do that. But if they turn around and say, hey, look, I want to put a couple of shelves up, you can say, yeah, that's okay, that's fine, but you need to take them out and fix up the damage when you leave. That's perfectly fine. But if you may decide, oh, that's a good job, maybe you could do that, you can leave that there. So you can actually impose conditions, or you could say, yes, you can do that, but you can do it over here instead of there. So you just have to engage, but we engage with tenants on your behalf anyway. We've got all the forms there. They have to do it in writing. We have to respond within a certain time frame. We can impose conditions, and it's like they can fix a TV on the wall or a shelf so it doesn't fall down and land on someone's head. It's for health and safety as well. And if they don't reinstate, it's a substantial penalty for the tenant as well, our landlord, if they don't do the right thing. But the tenant, if they don't reinstate, they have to pay for the reinstatement that will be done on their behalf, but also they risk a fine of $1,500. So again, removing that grey area, they have to request it in writing. They can't do it without, and it's really just stuff that make it in home. They're not going to add an extra story to your house. They're not going to paint it purple. There's actually nothing to worry about here.
And the benefits, I think, that you and I probably both found over the years is that allowing tenants to treat the property like a home, and I mean that includes things like getting pets as well, which is a different discussion, but more people can be made to think that it's their family home, or it's the home where they love spending their time, particularly now that we've been faced with these lockdowns and people have spent more time in their homes than ever. People will stay longer if they can make it into their own home. If you let them put in a veggie garden, or put the pictures of the kids up, put the diplomas on the wall, or whatever it is, people will stay longer if they get to treat it like their own home.
Absolutely. And it's just it's just starting the conversation, I think, too. If it's more than minor, but you think you might consider it, you can just ask for extra time to consider. So there's really good, if you have a read of it, it's really clear. It's actually really, really clear what is considered a minor change and what isn't. And in our minor change request form, I've actually put that in there so that people can have a read of it when they're reviewing, when the tenants making a request, they can see what they shouldn't be asking for. And also for our landlords, when we send the form off and say, hey, what do you reckon? Although we would always sort of recommend that. And the only thing to make sure is if you do sell your property, that you go, oh, by the way, that was a tenant's, not mine. So, but then we've trained our salespeople to make sure they're asking all those right questions.
So that takes us on to the next part, which is considered a property change. So this has been going on for a long time. Fibre broadband came out in New Zealand a long time ago, and most tenants do put the question to their property management company or to the landlord, or if not, then Chorus will actually contact the land agent or the property manager and ask for permission to put fibre in. This has just been formalised now. Obviously, there are so many people in New Zealand who want fibre. They've basically put in a process so that landlords can't unreasonably withhold permission to put fibre into a property.
No, and I don't know why you would, frankly. Why would you? I mean, everyone needs a Netflix. I know I've been watching Yellowstone. I don't know, recommendation there for you. Have been stayed up too late, so I've been watching it. But one thing that's, I said this to Deb earlier today, but it's, we've got a fibre request form. You are able to put in reasonable conditions, like where you put the box, because I moved into my home at the end of November in a rush to get fibre sorted, all this stuff was going on. I said, can you put it on that wall over there? And they did. And now I don't want it there anymore. So because it wasn't sensible, I didn't think it through. So your property manager will be able to actually say, hey, tenant, that's a great idea. Yes, of course you need fibre. Can you put the box over in this like little place where it's not going to be in the middle of your lounge room wall, which is something I was silly enough to do. So again, they have to ask us, they have to engage with us, and we get to go back and say, yeah, sure, of course, and be involved in the process. And in that way, we can impose a reasonable condition. So it's, again, good, it's clear. And I don't know why anybody would refuse somebody broadband when it's an important thing, especially with kids working, people working from home, kids studying, all of those things.
Yes, particularly after COVID when people are spending so much more time at home.
Oh, yes, last few days.
Assignment of a tenancy, this is an interesting one, and I have had lots of questions about this lately where landlords are thinking, my tenants are going to give the house to somebody else and I'm not going to be able to stop it. And so this is not what this is for.
No, I think this is, and I agree with you. I've had more questions over this, but I don't even think it's a thing. I've worked in the commercial space a lot, and that was, you would assign a tenancy, but they still had to be approved just like this. So what is going to be more likely if your tenant can't finish their obligations to you during the fixed term tenancy? We're talking about fixed terms here. They would say, hey, look, I've got an extra 6 months to run on my 12-month lease. Can you find me a new tenant? And then they would break their lease, you would find the new tenant, and then they pay all reasonable costs. That's the process now. And that's what's probably going to continue. Of course, we would have to approve it, if we did want to let them break their lease, that is still an approval process. But we typically do let people break their lease, providing they pay all the reasonable costs, and rent until someone else moves in. This here is saying that the tenant's going to come to you with another prospective tenant, all wrapped up in a bow with the name, contact details, and everything, which I think is actually unlikely. It could be that a family member wants to move in and take over. That might happen. But look, all it means is that they would have to come to you with the suggested tenant. You would only need to consider it, and you would only need to assign the current term. So if you had 6 months to run, you would only be expected to assign that. But if they don't stack up with all of the things that Deb would put them through with the credit checking and everything else, if they don't stack up, you don't have to accept them. Simple as that.
Not only do you not have to accept them, but if you can't reach an agreement on who's going to take over the tenancy, you can actually advise that you are going to relinquish the remainder of the term, essentially freeing the tenants from the rest of the tenancy. Oh,
absolutely. You can just say, hey, look, I don't want the new tenant. How about it? You can just surrender the lease instead and give me 28 days notice. Just come to an arrangement. So all you're expected to do is consider it and be reasonable. And if it's a regional tenant that they're putting to you to take over the rest of the lease, then it would be reasonable that you would accept that. But if they're not a reasonable prospective tenant, then you can decline. Or if you just go, meh, don't really want to, I'll surrender it instead. So you've still got the power. They have to ask you. They cannot do it without your consent. There are financial penalties if they do. So again, you've still got control here. It's just starting another conversation and giving people the option. Now, just so you know, all of our tenancy agreements up to the 11th of February all prohibited assignments. So we are only a few days into this new legislation. We're not being able to prohibit assignments granted from the 11th of February onwards. But I think we've got a few days before we're going to have to deal with this. No one's going to have signed up a lease a couple of days ago and want to assign already. So don't worry about this one. Break leases will still, I think in my opinion, be more common than anything, moving forward.
Okay, so keeping records, and from some of the tribunal cases that I've read about over the years, and I know that this applies primarily to private landlords where no record of any rent receipt has ever been kept, no record of any inspection, the bond hasn't been dealt with appropriately, it hasn't been lodged, there's no bond paperwork, there isn't even a signed tenancy agreement. This is all the stuff that typically private landlords, I'm sure there are some property management companies out there that do it as well. However, for Harcourts, who are a member of the Real Estate Institute, and any agency that does have an audited trust account, we have to keep accurate records available. We do have an auditor come into our offices and pour over everything with a fine-tooth comb. We also have to report all of our data, Jodine, to you, yes, in our national office. And if we have any intention of ever taking anyone to tenancy tribunal, we've got cloud-stored tenancy agreements, inspections, photos, the whole lot. So this doesn't apply too much to property management businesses.
No, we're fine. I mean, this is such a non-event for us because we're doing it anyway. But what's good is we've got the legislation there that says that people need to do it. And I think that's important. I think that's really important legislation to say that you must keep these records. We're doing it anyway, so it's not an issue for us, but it is important. It is important that this legislation is in there.
I think it's very timely, because if the cloud hadn't been invented and we were supposed to keep as much data as we do now, we would spend all of our annual income on renting space to store paper files. So thank God for the cloud, wherever it is.
Absolutely, somewhere out there. I'll just go back to, actually, I'll just touch on that, because I don't think we need to keep a record of all of our advertising for at least 12 months. And also any correspondence into with a prospective tenant. So for any of these people out there renting, trying to get their own properties, I think this would be a problem for them. But again, we have our one source of truth, where we have our database here, and if we update that, it updates everywhere that we're doing, so it's seamless. And so our business partners are taking snapshots of that, recording that in our diary. We've got copies of all of this, and also with notices of correspondence with anyone. What we need to prove is that we're not being discriminatory, and of course that's really important. We haven't discriminated, and we haven't encouraged rental bidding. So those are the things there. So anyone we've offered a tenancy to, we need to keep their records for 12 months as well.
Yeah. So I know that we're only going to touch on this briefly, but I think it's important for people to realise the difference between a single individual landlord and also what's considered to be, a much bigger landlord who should be responsible, because this is really becoming a business for them.
Well, I think even if you own one property, you are in business. I think that's really important. And it comes down to, the way I see it is, even if you own one property or 6, you must do the repairs. You must do these things, because you are in business. Just like if you're in business and you didn't want to pay your PAYE or your staff, it's treated the same, because these are a must now. These are not would you like to. These are a must. But I mean, again, you've got your properties managed, so we will tell you when you must or when you might want to. So we'll give you those options, but here, this includes us. So we would have granted more than 6 tenancies in one day at High Court. So we are also a large landlord, and we're supposed to know better. And landlords who own 6 or more properties should also know better. So this is really good, because we've got some large landlords in New Zealand. If you think back to some of the media over the last few years, and I know, Deb, you fired a landlord that wasn't doing what they had to do. Yeah. And we have to, because it's health and safety risks and all of that. We're supposed to know better. Landlords with 6 or more properties should also know better. So it's important now that there are bigger fines for people that should know better.
Okay, so other changes to the RTA. Now, some of these are part of other legislative changes. So as of the 1st of December, the privacy legislation in New Zealand changed for the entire nation. And there's now more that we need to be careful of in terms of keeping and storing, using, accessing and the accuracy of privacy information. And in addition to that, the tribunal have taken the step to say that if a party is successful in its claim in tenancy tribunal, they can opt to have their personal details hidden in the tenancy tribunal order. Now, I think that has a lot of people a little bit spooked, because they're thinking, well, if I take a tenant to tribunal, then it'll get hidden from record, and some poor property manager or landlord next time won't know that they've done all these terrible things to my house. Now, that's not the case.
No, this is for, and I come back to, look, we have got a history of some not so good landlords, and I've touched on that, and we will acknowledge that. But so what this means is that if a tenant stands up for their rights, if a tenant turns around and says, look, I've had my, a roof leak for 6 months, I've got water everywhere, I've got mold everywhere, and the landlord won't fix it, then they can apply to the tenancy tribunal, which of course can say, look, you need to fix it, you need to do X, Y, and Z and pay compensation extra. All of these things. What the tenants are scared of doing is, if they stick up for themselves, then they will never be rented to again by anybody. So if they're successful for sticking up for themselves, they will be able to ask to have that removed from public record. However, if they trash your property, and I know this is what people really could be concerned about, if they trash your property or they turn into a meth house, God forbid that would happen, but if they did something wrong, that's a matter of public record, they won't get their name suppressed. So again, this is only for people that, they should be able to stick up for themselves. Let's face it, I don't know if anyone's ever rented before and they've been scared of asking for something in case the landlord kicked them out. well, this is, you know, helping them here. So, and unfortunately,
I think we've all got friends and family who are scared to put their hands up to their landlord, even though they might have rain pouring through the ceiling on the inside, because they don't want to upset the apple cart or rock the boat. And essentially, that's just giving tenants a little bit of that extra safety and security in the tribunal to say that they're not going to be penalised in future if they do make a successful claim against their agent.
And look, again, it comes back to, are you doing the right thing or not?
Mm.
So if you're doing the right thing, this is good, because it'll take anyone else to task who perhaps isn't. This is an interesting one. I don't think we're going to get a rush of people, but it does mean in a situation here, say if you're going to have a husband and wife and there was a domestic violence matter, the victim could leave the tenancy and give 2 days notice, and then if the other person stayed, they're both named in the agreement, rent would be abated by then half for 2 weeks. There'll be a formula to work out how much to abate the rent by, but it's easy if you just work it out by 2, then it would go back to full rent. But what this means is that somebody who is a victim of domestic violence, or in a really unsafe situation, can leave without fear of financial penalty and having to pay the rent for the next 12 months. This, I don't think we're going to see a lot of this. This won't come into effect until August, and they have to give evidence, and they'll tell us what that's going to look like. But I don't think we're going to get a lot of this. People won't want their property manager to know. Probably not unless it's an extreme case, and in which case we would handle that with empathy and within the legislation. So this is just to make sure that we can keep our people safe. So I don't see a rush of people telling their property managers that they've had an issue.
Okay, so there's obviously there's been a lot of media, a lot of news. This has been going on for a couple of years now, from when the proposed changes were first tabled, right through the the selection committee, and into the later stages of this year. So to give people a little bit of comfort around the timeframes that mean the most. So as of the 12th of August 2020, there was a rent increase limitation to be done once annually, which all of our clients are aware of, and also the transitional and emergency housing being exempt from the RTA, which doesn't apply to most of our properties. Phase 2 is the very, very poignant timeline that we just passed, which is the 11th of February 2020. And that's when the majority of these new legislation changes comes into effect. There is a third stage to the changes, which is on the 11th of August this year. And that is for those that you mentioned previously, which is the family violence and physical assault. Now, there is still a whole lot more work to be done by MBIE around how these two will look. The family violence, as Jodine said, is basically about a tenant being able to exit a tenancy without fear of financial penalty to ensure their safety. The second one is more important, and that's physical assault by a tenant on their landlord or property manager. So if one of our inspection team goes to assess a property and they're attacked or they're abused or assaulted at the house, that does give the options to potentially move that tenant out with 14 days notice. So we're still waiting to see how that's properly packaged up, but that's another great tool to ensure that property managers and landlords are protected in the event that the worst case scenario transpires.
Absolutely, and again, no grey area, very, very straightforward. But legislation that we do not all pass, so we never really want to use. So, but it's there for us if we need to. So I think that's really good. There's some really good information out there. You can just speak to your team at Cooper & Co. Read the newsletters that they send you. Stay in touch with that information there. But there is a lot of information out there. Just be careful where your news sources come from sometimes if you're concerned about anything. I know, Deb, you guys are just so over this. I think all over this, not over this. So we can, I know that all your landlords will be able to come straight to you and your property managers as well and ask questions, won't they?
Absolutely. And look, we know that there's been a lot of changes in the industry, more changes in the last 2 years than there have been in the last 50 years. With the insulation legislation which came into effect in 2016, the Healthy Homes, the Residential Tenancy Amendment Act, there is a lot going on, and there is always going to be media hype around such big changes, particularly when it concerns such a large portion of New Zealanders who are either renting in rented properties or property managers. It doesn't all have to be doom and gloom though. A lot of what we found is just once people are aware of what the changes mean and the ones that will affect them, it's a lot easier to start navigating how you want to cope with that going forward. So look, it's here to stay. So much of it is really positive for property managers, for landlords, for tenants, and as an industry, we're really supportive of making these changes. I think it just requires having a team, whether it's dealing with the healthy homes or dealing with the new laws, deal with someone that you're really confident knows what they're talking about and is happy to navigate this on your behalf. And that takes a whole lot of the stress away.
Absolutely, absolutely. It's the same thing with the healthy homes, isn't it? If you know what you're doing, it's not so scary. And in a few years' time, we will have all the rental stock will be warm, dry, healthy homes. And how can that be bad? That's going to be a great thing for your investment, for your tenant. They'll stay longer. It's when you look at the why we need to do this as well, when you start looking at some of the stock that we had, we needed the legislation to make sure that these homes were warm, dry, and healthy for our fellow Kiwis. So it may be a little bit of a hurdle, but just trust your property manager and be guided by them. That's my advice. Obviously, I think if anyone's got any friends that could do with a property manager, reach out to Deb as well, because I think there's a lot of people out there perhaps trying to navigate this new legislation in healthy homes on their own as a part-time thing, and that would be hard right now. I think
well, this is a full-time thing now. There is no part-time doing it yourself. I think what we've learned during this experience is that there's never been a better time in the history of the world to have a property manager. I know how many hours I've spent poring over this and how many hours my team have spent, how many hours you've spent training them and the rest of the nation. It is very, very challenging to look at doing this yourself now. I'm not an accountant, so I don't do my own accounts. And if I wasn't a property manager, then I wouldn't feel comfortable anymore doing this myself either.
That's right. And one thing that we didn't want to do throughout this was focus too much on what the fines, what the penalties and everything are, but they have increased, they're high. And by having a property manager, they are across this. They are across these changes, or having the right property manager, I will say that though. And so getting it wrong is expensive. And I think one thing that we will start to see with tenancy is that with tenancy services and everything, there is an expectation now that we doing better, that we know more, and the tolerance to getting it wrong, I think, will lessen in time as well, because they are expecting landlords to get that right. So look, no better time to have a property manager.
Well, thank you so much for not just your insight today, but all of the work that's gone into supporting Harcourts New Zealand, their team of property managers. We really appreciate it. And I'm sure that we'll be doing this again at some point once the next round of changes are upon us. So thank you so much for your insight and knowledge. And to all of our clients who have joined this evening, thank you very much for your time. And if there are unanswered questions, then your property manager will get back to you in the coming days.
And Deb, I want to say thank you for keeping the team. They're a fantastic team to work with. I really appreciate all your support, and for having putting this together too, so that we can help educate landlords, and hopefully you guys, everyone out there today, also making a little bit more comfortable with the changes. It's a great initiative. So thank you for having me as part of it. I've enjoyed it totally.
All right. Well, let's look forward to see what the next year brings. All right. Thank you very much, everyone.